Right, you got Harrington here, guys. This is part 2 of our Depositions episode. So, same wardrobe, same background, but let's just dive right into it. Our Practice Makes Perfect is the podcast for business owners and real estate investors, siempre con un cariño especial para los clientes extranjeros. Part 1. Okay, first of all, recall, we're not dealing with taking depositions because as a client, there's really nothing for you to do. It's just my show. It's my job to deal with that. We are just talking about defending depositions, and we're not going to cover the territory we covered last episode. So if you've not seen the first part of this episode, please go back and do that. Today we're going to focus on 2 things. 1, what can you expect from the proceedings? And 2, how should you testify? Okay, part 2, what to expect. All right, well, probably the very first thing that's going to happen is that the court reporter is going to swear you in. And then the other attorney will be up. Remember, this is the other attorney's show, right? He or she is going to take lead for the whole process. And the first thing that attorney will do is give you some instructions, ask you things like, are you on medication? Is there anything that could affect your ability to answer completely and accurately? There's going to be sort of orientation moment there. Immediately after that, we'll get into the main part of the show, which is called direct examination. And that's the other attorney asking you questions and you giving those answers under oath. Now, this process can go on, probably all day and sometimes even multiple days. But don't worry, we're certainly going to take breaks. And be aware that we don't have a lot of control over how many questions the other attorney asks. Again, it's his or her show. Once the other attorney is done with the direct examination, then I or my attorney will have a chance to cross-examine you. Now let's dive into that just a bit. When would or would we not do that? Well, many times we'll just skip that. We won't ask any cross-examination questions. Remember from the last part of the episode where I talked about we really want you to spend as little time as possible under oath, having every single word that you say transcribed. So, we're very interested in getting you in and out of there. For that reason alone, we may refrain from asking any cross-examination questions. That's very common. Let me go one step further. Not only is that very common, but it's probably a good sign. It means we're happy with the way things went and let's just get the hell out. So then when would we take the time to go into cross-examination? Well, that probably means we need to rehabilitate you a little bit. That means, something I heard along the way I didn't like. Remember from the last episode, I have the ability to make objections along the way, but that's it. I don't get to coach you, right? So, maybe you said something I wasn't expecting you to say, or maybe I suspected that you didn't understand the question correctly. In any event, there's something that I feel is worth taking time to clarify. Now, remember, we do get to take breaks. So more than likely, before we get into cross-examination, I'm going to ask for a break. You and I are going to have a chance to talk. We're going to go over that issue that I'm concerned about. And you're going to know the purpose of the questions that I'm going to ask and the kind of responses I'm expecting to get from you. So you'll have that kind of preparation, generally. It is possible, however, that we won't have that opportunity. Remember, it's not my show. I don't get to control the timing on things. And it may just work out that there's no real chance for me to confer with you before we go into cross-examination. In that event, I just want you to be very alert. Remember this conversation we're having now. I would not be asking you any cross-examination questions unless I thought it was important to do so. So, if we go into cross-exam and I'm asking you questions, I need you to be very alert. And remember, you're going to be tired at this point. Probably. It's probably been an ordeal and we're all ready to get the hell out of there. But I need you to be alert because this could be critical. If I'm asking you questions, it's because I didn't like something that you put on the record. You need to be asking yourself, why is Jeff asking me this question? What did I say before? And do I need to, what do I need to clarify? And finally, after my cross-examination, then the other attorney is going to have a chance to redirect. And more than likely, that's going to happen because the other attorney just is going to interpret the fact that I'm asking cross-examination questions just the way I explained to you, that something went wrong or something unexpected came up. Or he or she is going to take this as a delicate issue and maybe one that could be a make or break issue. Otherwise, I wouldn't have asked the cross-examination questions. So you can expect that if there is a cross-examination, the other attorney is probably going to have some redirect because they're going to want to dig into that issue a little further. Part 3, how should you testify? What tips can I give you along those lines? All right, first tip is be frank and be sincere, right? Don't try and dance around the questions. Don't try and be the smartest person in the room. Don't try to outsmart the other attorney. One, you're just going to drag everything out because the other attorney's not going to stop or get discouraged. They're just going to keep going and the whole process is going to take longer, which is going to be more expensive for you. And two, don't forget, this is your practice trial. You know, we're all trying to see what kind of a witness you're going to be on the stand at trial. So if you're trying to be cute, if you're trying to be the smartest person in the room and you're evading the questions and you're doing all of that, how do you think the judge or the jury are going to respond to that? Are they going to like you? No, it's obnoxious. And two, they're going to think you're lying. And let me tell you something, once the judge and or the jury thinks you're lying, that's very hard to overcome. By contrast, if you come across as being sincere and likable, then you're a good witness for us, and the other attorney will likely want to limit the amount of time that you're on the stand. Next tip, control your temper. Now, I'm not saying that you should be a robot up there because, after all, you've been wrong, so a little righteous indignation is appropriate. It can even be persuasive, maybe expected. That's okay. But we don't want you flying off the handle and coming off like a jerk. As we just discussed, once the judge and the jury think that you're a jerk, I mean, judges are they're trained so that, they're not supposed to make their decisions based on personalities. They're supposed to make their decisions based on evidence, but they're human too. So, help me help you. Don't make them dislike you. And be aware that the other attorney may purposely goad you. Sometimes they do this. They want to see how you handle your emotions. They're trying to determine, how to best get to you and get under your skin maybe while you're on the stand so that you will have some sort of an outburst so that people will dislike you and, be aware of all that. All that gamesmanship is happening. Okay, last one, and this one's probably pretty obvious, but it's worth talking about because there's some nuances. Only answer the questions you're being asked. Okay, now, that seems obvious, right? Again, we're trying to get you in and out of there as quickly as possible, so be concise, don't ramble. That said, I understand that many people just, that's their normal way of communicating. It's not easy to give a super, Dr. Spock-like response to questions you're being asked. Some people, kind of take their time getting around to answering the question. That's okay. Listen, I don't want you to try to be somebody other than who you are. I mean, go ahead, as long as you don't, harm the case by just saying something I wasn't expecting you to say. I'm probably just going to let that go. I'm probably not going to interrupt you a lot. After all, it's the other attorney's job to get good answers out of you. And if you're not making it easy on him or her, well, it's going to drag out the process. But, otherwise, that's their problem. So I'll probably let it go. Just remember, don't do it on purpose. That has to be like your regular style of communication because otherwise, the judge and or the jury are going to detect that. They're going to detect you're being obnoxious. That will have a negative effect. And then also bear in mind that, you're the one paying for my time. So you probably want to try and stay on track as best you can. And that's what I've got for you guys. Those are depositions for you. There are a few more things to talk about, but, I think we covered the basics. And so recuerda que hablamos español. You know what you got to do down here. Give me some comments, give me some likes, send this to people, help a brother out. And I will talk to you about something different next week.